I'm here with Stuart Anderson, who is Executive Director of the National Foundation for American Policy, also a Forbes contributor. Stuart, nice to see you.
Thanks for having me back.
Well, we're talking about the gift that keeps on giving, H-1B visas. This time, the starting point is a court ruling related to the spouses of those visa holders. Tell us a little bit about the context of what's going on.
Well, in 2015, the Obama administration issued a regulation that allowed the spouses of H-1B visa holders to work if the principal H-1B had filed for their employment-based green card and been waiting a certain period of time. And basically two categories, but that's essentially what it was. A group called Save Jobs USA filed a lawsuit claiming that the Department of Homeland Security did not have the authority to issue that regulation and allow the spouses to work. At the same time, the same group, or a similar group, I should say, had filed suit in another court, saying also that the Department of Homeland Security didn't have the right to issue work authorization or extended work authorization for international students. So what ended up happening in both these cases is there was a long delay as the court even decided whether the folks filing the lawsuit actually even had standing to go ahead and file the lawsuit. Eventually, it was decided that they did have standing, and you had this case on the spouses. But what had happened in the meantime is that the spouses case ended up being largely decided on the basis of the international student case having been come out in favor of the international students and universities and their employers.
So it set a precedent,
and
basically.
Also the Department of Homeland Security on a 2-1 DC Circuit Court decision, saying that they did have authority to issue employment authorization to these international students. And so then when you look at this case, you'll actually see the judge actually says the plaintiff's primary contention is that Congress has never granted DHS the authority to allow foreign nationals like H-4 visa holders, the spouses, to work. But then the court says that the analysis of the WashTech case, which was the international student case, is, quote, directly applicable to this case. So really what happened was that another group called Immigration Voice intervened in the case to try to represent also the interests of the spouses, and companies and some associations also filed an amicus brief. And that gave the judge kind of a more rounded view than just having the group that opposed the rule have their point out there. But in the end, really what ended up being, decisive, probably overall, was the fact that a different decision had already decided that that DHS did have the authority, a very wide-ranging authority, to issue work authorization, and the judge applied that ruling to the spouses.